Clear agreements do not destroy trust, they protect it. If someone says, "Why do we need paperwork? You don't trust me." The answer is, because I do trust you, I want both of us to know what we agreed to. We are not here to chase every headline. We're here to build judgment. One episode, one idea, one framework at a time. Every deal has risk. The real question is who agreed to carry it. Most people learn the rules after the conflict starts. They learn what a personal guarantee means after the business is already behind on rent. They learn what the partnership agreement says after the partners are already angry. They learn what the contract actually does after the deal has already gone sideways. By then, the question is usually not what is the best decision. The question becomes, how much damage are we trying to contain? This is exactly why this show, Law, Land, and Capital, exists. Because business, real estate, capital, and the law do not live in separate worlds. They collide in real life. They collide when someone signs a lease, starts a company, brings in a partner, raises money, buys a property, guarantees debt, or tries to get out of a deal that no longer works. So if there is one idea behind this show, it is this. How you doing? I'm Edison Titus. I am an attorney, have been for about 11 years now, roughly. And I specialize in business, real estate, estate planning, probate, and private securities. I have an interesting background, former military, and lots of various entrepreneurial activities, everything from nightlife all the way to trucking and electronic medical records. So I guess you could say that I am a entrepreneur who happens to be a good attorney, right? And so I think that gives me a unique insight and understanding to the things that need to be considered all around when it comes to business. You know, the legal side, the financial side, the business judgment side, and of course, real estate. These things often overlap, and sometimes, a lot of times, lawyers are just lawyers. And everyone else, they know their profession, whether it's business or finance, but to have the necessary knowledge or enough necessary knowledge in all areas to tie it all together, I think that's my strong suit. And so welcome to Law, Land, and Capital, where we talk about the legal, business, real estate, and capital issues that serious people need to understand before things go sideways. This is episode 1. So today I want to answer the obvious question. Why this show? Why Law, Land, and Capital? Why put these ideas together? And the reason is simple, because in real life, they're already together. A business decision is rarely just a business decision. A real estate decision is rarely just a real estate decision. A capital decision is rarely just about the money. And a legal issue usually does not begin in the courtroom. It usually begins much earlier, with a signature, a handshake, a promise. A lease, a loan, a partner, a deadline, or a decision that felt ordinary at the time. So today I want to set the foundation for the show. We'll talk about the gap this show is trying to fill, the kind of decisions we'll be unpacking, the way I want you to think about this risk, and how this show will work going forward. Now, I wouldn't be a lawyer if I didn't have a disclaimer in here, right? So, quick legal note before we get into it. This episode is general education and commentary. It is not legal advice, and listening to this show does not create an attorney-client relationship. I never even met you. Every situation is fact-specific, and the law can change depending on where you are and what your documents say. So if you need advice about your specific situation, speak with a lawyer licensed in your jurisdiction. Here's the problem I keep noticing. There is plenty of information out there about business, about real estate, finance, and capital. And there's plenty of legal content too. But most of it lives in separate lanes. A business person talks about growth. A real estate person talks about the deal. A finance person talks about the money. A lawyer talks about liability, contracts, disputes, blah, blah, blah. And each of those perspectives can be useful. But the most important decisions usually happen where all of those things overlap. That's the gap. The overlap is the gap. Because the person signing the lease is not thinking, I am now entering a legal structure that affects my business model, my capital needs, my personal exposure, and negotiating leverage, and possibly my family's financial future. They're usually thinking, this location looks good. They're thinking the rent seems fair. The broker says this is normal. I need to get this done. And that is where serious mistakes happen. Not because people are careless and not because people are unintelligent, but because they're making decisions in one category while the consequences show up in several other categories a year down the road. Let me give you an example. This is not a client story, it's a hypothetical. But it's the kind of thing that happens in the real world all the time. Imagine a man named Marcus. Marcus is 42 years old, and for the last 15 years, he's worked in construction management. Marcus knows projects. Marcus knows crews. Marcus knows vendors. Marcus knows how to deal with job sites when things do not go according to plan. But after years of building other people's companies, Marcus starts thinking, why am I not building something for myself? So he decides to open a small commercial flooring showroom. Not a flashy startup, not something he's trying to sell to Silicon Valley, a Main Street business. Local customers, contractors, suppliers, inventory, leases, employees, cash flow. A business that has to work in the regular world. He has saved some money. His wife supports him. His brother says he can help with operations. A few contractors tell him, when you open, we'll send people your way. So Marcus starts looking for space. After months of searching, he finds a location that feels right. It's on a busy road. It has enough parking, it has visibility. The landlord seems reasonable. The broker says this one will not last. And Marcus can already picture the sign on the building. For the first time, the business feels real. Then the lease comes. It's long and dense. It's full of language that Marcus doesn't really understand. But the rent number, it looks right, the location looks right, and everyone around him is acting like this is just part of the process. The broker says it's standard. The landlord wants it signed. Marcus does not want to lose the space. And in his mind, the biggest decision is whether this is the right location. So he signs. And in that moment, Marcus thinks he has made a real estate decision. But he's actually made a legal decision. He made a capital decision. He made a business decision. And depending on what he signed, he may have made a personal risk decision. Because buried in that lease might be a personal guarantee. The build-out timeline may be vague. The repair obligations may be broader than he realized. The landlord may have strong remedies, too strong, as a matter of fact. There may be no clean exit if the business takes longer to open than expected. Then the problems start. Permits take longer than expected, the contractor falls behind, the showroom opens 3 months late. Revenue is not coming in yet, but rent is still due. The landlord wants that payment. Marcus is trying to protect the business, protect his family, protect his reputation, and keep the dream alive. Now that the lease is no longer just paperwork, it is leverage to the benefit of the landlord. And suddenly the issue is bigger than rent. It affects his business, his cash flow, his family, and his future. And that's why Law, Land, and Capital exists. Because people like Marcus do not need a legal lecture after everything has gone wrong. They need a better way, a better framework of how to think about things before they sign. Here is the first framework I want to give you. Serious people make legal decisions before they realize they are legal decisions. That is true for business owners. It's true for real estate investors. It's true for developers, operators, lenders, founders, partners, contractors, landlords, tenants, and Basically, anybody who's simply trying to make a good decision with the information that they have. A legal decision does not always look like a legal decision. Sometimes it looks like signing a lease. That's simple enough, right? Sometimes it looks like agreeing to split profits with a partner. Sometimes it looks like borrowing money. Sometimes it looks like guaranteeing a loan for a company you believe in. Sometimes it looks like letting someone use your land, or delaying a deadline, or accepting a verbal promise, or moving forward before the final agreement is fully clear. And again, none of those things are automatically wrong. The issue is whether you understand what the decision actually does. A contract does not become important when the dispute starts. It is important the moment you sign it. A guarantee does not become important when the business defaults. It is important the moment you agree to be personally responsible. A partnership agreement does not become important when the partners are fighting. It is important at the beginning, when everyone still trusts each other and the rules can be written calmly. That is one of the hardest lessons in this space. The legal consequences often begin long before anyone calls a lawyer. The second idea is this. Most people wait too long to understand the risk, and this is very human. When a deal is exciting, people want to move. When a business opportunity is in front of them, they do not want to slow it down. When the other side says this is standard, they do not want to look difficult. When a partner says, you trust me, right? They don't want to sound suspicious. So people tell themselves, we'll fix it later. But later is almost always more expensive. Later is when the money has already moved. Later is when the document has already been signed. Later is when the partner already owns part of the company. Later is when the landlord already has the guarantee. And it's also when the investor already has rights. Later is when the deadline has already passed. And at that point, you may still have options, but they're usually more narrow, more expensive, and definitely more emotional. That is why preparation matters. Preparation does not mean you become afraid of every deal. It does not mean you become impossible to work with. It does not mean every conversation turns into a legal negotiation. It means you slow down, just long enough to ask better questions. Where does the risk go if this goes wrong? Who is personally responsible? What document controls? What happens if the other side does not perform? What happens if we need money? What happens if we need to exit? What proof would I have if this becomes a dispute? Those questions are not negative. They are responsible. The third idea is the title of the show itself. Law, land, and capital are connected in real life. They're besties. When people hear law, they may think of courtrooms, contracts, lawsuits, disputes, lawyers. When they hear land, they may think of real estate, property, development, leases, buildings, title, ownership. When they hear capital, they may think of money, financing, investors, debt, equity, cash flow. Or maybe they're thinking about the securities, the 506, B and C, the Reg A, 504. Who knows? But in the real world, those ideas constantly interact. Take a real estate development project. You have land, but you also have financing. You have financing, but you also have contracts. You have contracts, but you also have timelines, obligations, remedies, liability, investors, construction risk, tenant risk, market risk, and exit risk. Or take a business partnership. It may start with trust, but eventually it comes to ownership, authority, contribution, profit, debt, distributions, buyouts, tax consequences, and decision-making power. Take a commercial lease. It is about space, but it's also about personal exposure, operating expenses, maintenance obligations, default remedies, business interruptions, build-out costs, and the capital required to survive delays. That is the world this show is interested in. Not law in isolation, or real estate in isolation, or money in isolation. The point is to look at the decision the way it actually works in the real world, where the deals the dollars and the documents live together. That phrase matters. The deal is what people think they are doing. The dollars are how the economics actually work. The document is what controls when memory, optimism, or trust are no longer enough. A serious person needs to understand all three. Now, let me be very clear. This show is not here to turn you into a lawyer. It is not here to give you individualized legal advice. I've never even met you. It is not here to make you think you can handle every legal issue. It is not here to replace counsel, and it is definitely not here to give you a false sense of confidence based on a few minutes of content. The goal is different. The goal is to help you think better, to think with frameworks, to understand what to think about and how to think about it, right? Because there is a huge difference between knowing every legal rule and knowing when you need to slow down. There's a difference between being able to draft a contract and being able to recognize that the contract matters. There's a difference between understanding every technical term and understanding that the risk has to go somewhere. That is what I want this show to do. I want it to give you language. I want it to give you frameworks. I want it to help you notice the warning signs earlier. I want it to help you ask better questions when you're talking to your lawyer, your partners, your investors, your brokers, your lenders, your contractors, and even your own employees. Because the better questions change the conversation, it makes for better decisions. And that's what I want, for you to decide better. Instead of asking, can I get out of this after the deal goes bad, you might ask, what is my exit if this does not work? Before you sign. Instead of asking, can my partner do that after the relationship breaks down, you might ask, who has authority to make the decision? Before the company forms. Instead of asking, why am I personally responsible for this after default, you might ask, am I signing this individually or only on behalf of the company? Before you agree. This is the kind of thinking this show is built around. Let me give you a few mistakes I want this show to help people avoid. The first mistake is confusing trust with protection. Trust matters, relationships matter, reputation matters, but trust does not replace structure. You can trust someone and still need a clear document. In fact, sometimes the closer the relationship, the more important the documents become. Clear agreements do not destroy trust, they protect it. Because when the agreement is clear, people do not have to rely on memory, assumptions, or emotion when pressure shows up. And pressure will show up. The second mistake is assuming everything can be fixed later. Sometimes it can. Many times it cannot be fixed cleanly. Once money moves, once rights are granted, once a guarantee is signed, once a partner is admitted, once a default occurs, the options may change dramatically and quite possibly not to your benefit. The third mistake is thinking that being right means being prepared. You may be morally right, you may even be legally right, but if you do not have the documents, the records, the emails, the timeline, the proof, the strategy, being right may not be enough. This is something serious people need to understand. Disputes are not just about who feels right, they are about leverage, evidence, timing, cost, patience, and the documents that control the relationship. The fourth mistake is treating legal review as something you do only when the deal feels dangerous. Sometimes the deals that feel friendly are the ones that need the most clarity. Family deals, friend deals, informal partnerships, simple leases, verbal promises, handshake agreements, those are often the situation where people skip structure because they do not want to make things uncomfortable. But discomfort early is often cheaper than conflict later. So what should you do instead? First, ask where the risk goes if things go wrong. Every deal has risk. The real question is, who agreed to carry it? Is the risk on the business, on the owner, on the tenant, on the guarantor, the investor, the contractor, or on the person who thought that they were just helping. Risk does not disappear because no one talked about it. It goes somewhere. Second, separate excitement from judgment. Optimism is good for starting. Judgment is what keeps you alive. You can be excited about the opportunity and still read the documents carefully. You can trust the person and still define the responsibilities. You can want the deal and still ask what happens if it fails. Those things are not contradictions. Third, learn to spot warning signs early. You do not need to know every rule, but you should recognize certain red flags. Rushed signatures, vague responsibilities, personal guarantees, unclear authority, missing deadlines, verbal promises, broad indemnity language, weak documentation, and people saying, "Don't worry about that." Sometimes "don't worry about that" is exactly when you should worry about that. Fourth, ask better questions before you ask for answers. A lot of people wait until the problem is fully formed and then the questions become urgent. Can I sue? Can I get out? Am I stuck? Can they do this? What happens now? Those may be necessary questions at some point, but the better questions come earlier. What am I personally responsible for? What happens if the other side does not perform? What happens if we need to exit? What documents actually control? Who has authority? What happens if the business needs more money? What proof would I have if this becomes a dispute? Fifth, understand leverage before the fight starts. Leverage is not just who is right. Leverage is who has the documents, who has the evidence, who has the timeline, who has the cash position. Who has the contract language, who has the patience, and who has a realistic strategy. You build that before the conflict, not after. So what should you expect from law, land, and capital? We're going to talk about the issues that sit at the intersection of legal judgment, business decisions, real estate, and capital. That means partnership, entity structures, contracts, commercial leases, real estate deals, financing, capital stacks, risk allocation, liability, disputes, negotiation, exits, buyouts, guarantees, investor issues, operator issues, administrative rules for the cocktail of agencies that might govern what you've got going on. The decisions that shape the deal before anyone is fighting about the deal. Some episodes will be solo deep dives, like this one. One topic, one framework explained in plain language. Some episodes will be interviews. I want to bring in people who see these issues from different angles. Lawyers, investors, lenders, developers, operators, business owners, and people who understand how deals actually work on the ground. Some episodes may be panels, because not every serious question has one clean answer. Sometimes the value is in hearing several sharp people disagree honestly about the same issue. And the range will vary. Some episodes will be foundational for people who are newer to the topic. Others will go deeper for people already in the arena. But the standard will be the same. Plain language, serious thinking, no hype, and no pretending that complicated issues are simple just because simple content performs better. That matters to me. Because the internet is full of confident answers, what serious people need is better judgment, or at least better ways to think about the things that lead to better judgment. Here is how the show will work. Solo episodes will usually be about 20 to 30 minutes. The goal is to take one idea and do it well, not to cover every possible exception in one sitting. The episodes are meant to be evergreen. That means we're not chasing the daily news cycle. We're talking about principles, frameworks, mistakes, and questions that should still be useful long after the episode comes out. Interviews and panels will flex based on the topic. Some conversations need a practitioner, some need a lender, some need someone who has operated business, developed a property, raised capital, or lived through a deal that did not go as planned. On air, we will stay conceptual. If something is specific to your situation, that is a conversation for your own counsel. But conceptually, we can still learn a lot from scenarios, patterns, hypotheticals, and the questions people should be asking. The style of the show is simple: clarity over showing off. There's no value in using jargon just to sound sophisticated. If a concept is technical, we will explain it. If an issue is nuanced, we will not pretend it is simple. But we will also not hide behind complicated language when plain language works better. I also want this show to become a two-way show. So if you have a question, general question, a what-if scenario, or a situation you think other people could learn from, send it in. Now for a few important guardrails. Do not send confidential information. Do not send privileged information. Do not send identifying details that should not be discussed publicly. Keep it general. Keep it hypothetical. Frame the question in a way that could help other people too. For example, instead of sending, here's my exact lease and here's my landlord's name, and here's everything that happened, a better submission might be, what should a small business owner understand before signing a commercial lease with a personal guarantee? That kind of question. It can help a lot of people. Or instead of sending private details about a partner dispute, you might ask, what should partners decide before they start a business? The best questions may become full episodes because if one person is wondering about it, there's a good chance many other people are wondering about it too. So please send in the questions, send in the hypotheticals. And while I do encourage you to be detailed and specific in that specific manner of what you're asking, please do not be specific in your scenario. Let's bring this back to the main idea. Business, real estate, capital, and the law do not live in separate worlds. They overlap constantly. And many of the most expensive problems begin when people make decisions in one lane without understanding the consequences in another. Marcus thought he was signing a lease, but he was also taking on legal obligations, business pressure, capital risk, and possibly personal exposure. That is the pattern. A founder thinks they are bringing in a partner, but they are also creating governance issues, economic rights, exit problems, and future control questions. An investor thinks they are funding a deal, but they're also accepting risk based on documents, collateral, priority, representations, and remedies. A business owner thinks they are signing a contract, but they are also deciding who carries the risk if performance fails. A landlord, tenant, operator, lender, contractor, developer, or partner may all be looking at the same situation from vastly different angles. But the documents, the money, the property, and the legal rights are all part of the same reality. That is why this show exists. Not to make you fearful, not to make every deal feel dangerous, not to replace legal advice, but to help you become more prepared. Because preparation changes the way you enter the room, it changes the way you read the document, it changes the questions you ask, it changes how early you involve counsel. It changes how you think about risk, leverage, ownership, money, and your exit. And sometimes that earlier thinking is the difference between a manageable issue and an expensive problem. If you remember nothing else from this first episode, remember these points. Number one, serious people make legal decisions before they realize they are legal decisions. Number two, most people wait far too long to understand the risk. Number three, business, real estate, capital, and the law are connected in real life. Do not treat them like separate worlds. Number four, the goal is not to turn you into a lawyer. The goal is to help you think better, ask better questions, and recognize warning signs earlier. Number five, every deal has risks. The real question is who agreed to carry it. Number six, later is usually more expensive. Do not assume everything can be fixed after the signature, after the money moves, or after the conflict starts. Number seven, clear agreements do not destroy trust. They protect it. And finally, number eight, better questions early can prevent desperate questions later. And that is episode 1 of Law, Land, and Capital. If this was helpful, do me a favor, like, follow, subscribe, and share it with someone who is building a business, buying a property, signing a lease, entering a partnership, raising capital, or trying to make serious decisions before things go sideways. And if you need a consultation or referral, you can call us over at the Titus Law Firm. You can find the link in the description. Next episode, we're talking about partnerships and why partnership is not just a relationship, but a structure. Because most partnerships begin with trust and they survive because the rules are clear. One more reminder, this episode is general education and commentary, not legal advice. Every situation is fact specific, so if you need legal advice about your situation, speak with a lawyer licensed in your jurisdiction. I'm Edison Titus. This is Law, Land, and Capital. And remember, own the structure before the structure owns you.